Kennedy Graham.
Thank you, Mr. Speaker. Let me begin by reiterating, not for the first time, an appreciation of the manner in which the Justice Select Committee operates and under the benign and competent chairmanship of Chester Burrows. We're tending to repeat this every time, and I just wonder whether Mr. Burrows is starting to feel a certain ennui in terms of the accolades that are being given to him every time. Perhaps we can relieve him of this in the future, but just regard it as read each time. But I don't intend in any way to diminish the sincerity with which I say that. It is a good committee. It does cooperate very well indeed. That said, I would not wish the House to wax under the misapprehension that Mr. Quinn perhaps offered, that all is total harmony and sweetness and light on this bill, because the Green Party does remain opposed to it, although for reasons that I will explain later, I do take personal responsibility for part of that misapprehension arising. Let us just recall for the moment the basic aim of the bill, which is stated to reform the legal aid system by replacing the Legal Services Act 2000, and that aim and method is based on the Baisley report, which of course was not just one person, it was a group of people, and it recommended a variety of reforms which can be boiled down to four principal reforms. First is to disestablish the Legal Services Agency and transfer the administration thereof into the Ministry of Justice and create a separate independent statutory officer first. Secondly, to replace the Legal Agency Review Panel with the Legal Agency Tribunal, Legal Aid Tribunal. And thirdly, to increase the quality assurance and performance management and application processes for the greater efficiency of justice. And finally, fourth, to clarify that legal aid can be obtained for the Waitangi Tribunal proceedings. For our part, we certainly had no difficulty with the last one, the fourth point. We were in favour of that, but we did have difficulty with the other three. The transformation of the Legal Services Agency inside and its folding inside the Ministry of Justice. We preferred that it remain at arm's length from the government to avoid any potential conflict of interest. Jacinda Ardern spoke about a certain confidence level in the public being required for that without really offering views as to how that could be obtained. And for our part, we are a little less convinced that that would obtain automatically. So we are not convinced on the merits of that. The second point, replacing the panel with a tribunal that would be chaired by a non-lawyer, we remain opposed to, notwithstanding the committee's deliberations. We think that casts an aspersion on the legal profession that is unwarranted. And the third point, the zeal for administrative savings, of course, greater efficiency and value for public funds is a principle. But if it tarnishes the equal or greater principle of natural justice, then we have to have pause. And we are not convinced, well, we are fearful that natural justice is being tarnished. So, with due regard to the constructive discussions in the committee itself, we are not persuaded that our basic concerns have been met. And we are not alone. May I quote simply one submission from a well-recognised legal authority in New Zealand, that's Tony Ellis, and I quote, "The Baisley report upon which the bill is premised is not the silver bullet many believe it to be. The report contained many unsubstantiated and unnecessary attacks on lawyers, particularly on those from Manukau and Palmerston North, which were unsupported by any meaningful evidence. This exposes the legislation to what in reality is happening. There is no real effort to attack the problems within the system. just a smokescreen brought about by a desire to save money triggered by a public denunciation of lawyers' incompetence by the Baisley report. Now, I know these matters are complicated, and I know there are problems within the legal aid system. But let us not engage in the misapprehension that this bill, which no doubt will become law, is the silver bullet to all of that, or that the opposition to it is misguided because it is shared by learned legal authorities. And not for the first time, I think that legislation that is being pushed through the House by the government, with great respect to the Minister and the Chairman, is not necessarily perfect. And so, for our part, we feel constrained to continue to oppose. Now, that said, just a word on the procedure, Mr. Speaker, if I may, and as with a certain note of personal apology. We in the Green Party had offered opposition, as I have described, and I did my best in the committee to explore those issues. It so happened that at the end of last year, at the beginning of December, on personal family reasons, I was called away from the House and from Wellington, and I missed to the day the draft report coming out on the 2nd of December and the committee discussion on the 9th, the 10-day period that I was away. As a small party, we were unable to have someone present at the time. I take it upon myself the responsibility that should have got word through that we continue to oppose, so that the Select Committee report would have said by majority, but I was so preoccupied that I did not do that. I apologise to the House. I would just like it understood that we do continue to oppose it in the second reading here, and we look forward to further discussion, perhaps in the committee and in the third reading, but it would take something for us to alter our minds at this stage. Thank you.